Awesome. Well, we'll go ahead and get started. Good afternoon, everyone. For those of you I don't know, I'm Jake Becker, the Compliance Manager here at BAM. It's my pleasure to introduce your two panelists for the next hour here, Corrine Combe and Dan Haynes with Ascendant Compliance, the division of CSS. They're here. Vicki and Keith are also here with Ascendant. I also want to take an opportunity to introduce our newest BAM compliance team member, Amanda Robinson, who's in the back. So tons of compliance support in the room. I'll hand it over to these two. If there's questions, we'll stick around afterwards. I know you guys will be available. Our team will be here as well. So without further ado, hand it over to you guys.
Thanks, Jake. So just for the purpose of the new people that we may not know from the Loring Ward side of the business, a little bit of background. Ascendant has been working with over 100 of the BAM Alliance members for over 12 years. We have a really great working relationship with BAM, so we understand and we work collaboratively on what they're introducing and how it may impact the compliance program for advisors. We know many people here. We have the pleasure of working with many of the advisors. I have to say, and I think this is the most thing that we're most proud of at Ascendant, but many of the firms that have gone through either state or SEC examinations recently have had really, really great results. We've even had a few that had no deficiencies whatsoever. I don't really think that's just a testament to us in the program we give you, but for all of you that are following the program, that's a huge testament to you. So we will be talking about what we see with the SEC and the states, but even though we have a set amount of things that we would like to hit on today, really, this is for you. So if there are any topics that we don't hit on, we will definitely leave a few minutes at the end for questions. And we do ask at any time during the presentation, if you have a question, please feel free to just shout it out or raise your hand. This is a nice group of, smaller group of people, so it's really intimate. So
one other housekeeping item that Julia mentioned is that if you did not get scanned, make sure you get scanned right away so you get credit for this.
Yeah.
So.
Yeah, because you will get CE credit
for
this. Yeah.
Yes.
So today we're going to hit on some of the new regulations and rules that have come out. Specifically, we're going to address regulation best interests and how that's going to impact the investment advisory industry. We're going to give a high-level overview of what we're seeing in examinations. I have to say that the SEC particularly has gotten very busy, very. We have seen a significant uptick in regulatory examinations by the SEC in all various different shapes and sizes, full-blown exams, cyber exams specifically, remote exams. So we'll share our experience of working with members of the BAM community and non-BAM community on what we're seeing, because I think that's the best way, for us to provide feedback. We're going to hit on the many risk alerts that the SEC has provided this past year. And then Dan and I are going to speak about cybersecurity and the new California specifically, but there are many other privacy regulations that are coming out. And we will also hit on briefly the CFP changes to their code of conduct, because a lot of that overlays with the fiduciary rules as well. So I'll kick it over to Dan to start.
All right, thank you. And thank you to BAM and to all of our clients in here. It's great if I haven't had a chance to meet you yet. I'd love the opportunity. It seems like a homecoming for me to come back to the BAM conference every year, having worked with you all at BAM for so long. So if I haven't had the chance to work with you or have a conversation, I very much would appreciate that. But one of the themes that we talk about with this conference is the fact that there's a science element of it. So one thing that I thought about as we try to weave that into our presentation is the fact that compliance is a dynamic thing. There are new elements being discovered all the time that you should be adding to your compliance program. And one of the most significant and also really recent changes or additions to your program coming up is actually, it was just passed in June of this year. And for the purposes, it was a 4-part rule that, we're not going to get into all 4 parts of it, but I think that specifically for you all, we're going to focus on Form CRS and Reg BI. And this is really the SEC's attempt at furthering their mission of making sure that retail investors are protected, that retail investors are educated, and that they're able to make good decisions and really understand the type of professional that they're working with, whether it be a broker-dealer or an investment advisor. And so as we look at this legislation or this rule package, we feel like this is the current SEC chairman, Chairman Clayton. This was his really signature move, what he wanted to accomplish during his time at the SEC. And this is really coming on the heels of the Department of Labor's failed fiduciary rule. That I know that we talked about in previous presentations here, that we've talked about in our alerts, and we wrote policies and procedures, and then it got vacated. And so as a quick background, the Department of Labor wanted to require a fiduciary standard across the board for broker-dealers to meet your registered investment advisor responsibility, and that was struck down. There was a lot of money, a lot of lobbying against it, and the courts basically said it is too far-reaching, it is unreasonable to think that people could be getting advice in their best interest if they're going to a broker-dealer. So while that fundamentally makes me cringe that people can't expect that standard, I do think that it is a good thing overall for the RIA community, because that continues to be a differentiator. And so that standard is moving a little bit, but with the standard being where on the next slide, what they really wanted to, what I think is going to be the biggest change to the folks in this room is going to be Form CRS. So it's client relationships, it's customer, client.
Yeah, there was a lot of discussion, just like how there's Form ADV, and everybody asks us, what does ADV stand for? Well, the rule actually doesn't define it, but it's being referred to as the Customer Relationship Summary Form. And for the registered investment advisors, it is also going to be your ADV Part 3 when you file it with the SEC as of 2020.
Yeah, so we wanted to start the conversation about Form CRS to first talk about timing, to say it was passed in June, but there's literally nothing you can do to adopt anything until May of next year. So we've got some time. Don't sit down and think, oh, well, what is this? It was passed in June. Why am I just now finding out? Or why haven't we done anything about it? So what Form CRS, you have to adopt it at some point between May 1st and June 30th. And then you have to, once you adopt it, which will be an upload into the IARD system, you have 30 days to send it out to your clients. And it's interesting that they actually specifically said when you send it out to clients, it needs to be on top of the packet that you send. And so as we think about practical rolling things out and working with BAM, we were thinking, you know what, it makes sense to do it at the end of June, to adopt something at the end of June, so that you have July when you're sending out your reports to folks. You can just include this in with the report package for Q2. So you have to do a separate mailing. It doesn't have to be an event and really draw attention to it. It's just one of those easy, you've already got this vessel for delivery, let's just adopt it at that point. And so you will get, for the clients of ours, we will be drafting your Form CRS for you. We'll give you drafts well before the deadline, so that you will be able to see what it looks like and be comfortable with it. But the idea behind Form CRS is that they can easily compare an RIA versus a broker-dealer, and then we have a third category of dual registrants, so that people can understand who it is that they're hiring. And if you think back to the regulation, how it's changed over the years, there was, I don't know however many years ago, there was a big rewrite of Form ADV. And the Form ADV, just to refresh everyone's minds, there's 2 parts, soon to be 3. Part 1 is something that is online. It's literally check the box, fill in the blank. Everybody's literally looks the same. Part 2 is a narrative format. That's what you actually should be handing to your clients right when they sign up with you, and then you have to make an offer going forward. So your Part 2 is made up of 2A, that talks about the firm, what the firm does, how you're compensated, things of that nature. And then 2B talks about your individuals, the backgrounds of the people who are giving investment advice. And so a few years ago, they rewrote the instructions for your Part 2 because it was kind of all over the place. Everyone's Part 2s looked a little bit differently. And they said, look, we want to make sure that this is a standardized process across the board so that when someone is comparing one firm to another, everything falls in line. The same headings, the same order, the same language, all that kind of stuff. And so now they're taking that same approach to comparing the broker-dealers to the RIA community. And so if we look at the structure of what Form CRS is, the concept behind it is layered disclosure. I like to refer to it as repeated disclosure. And the first time I heard the concept of layered disclosure, I didn't really understand it, but then I thought of it from the standpoint of growing up, my mom gave me lots of layered disclosure. My wife gives me lots of layered disclosure. She has to tell me multiple times for it to stick. And I think that's the idea with disclosure is you don't just tell somebody one time, it's going to be throughout your materials. And so it's already covered in your, like I mentioned, your Part 1, Part 2A, 2B. There's really not any new information that's going to be given in your Form CRS. It's just going to be in a different format because the idea is it's no greater than 2 pages for an RIA. You cannot go over, and it's interesting, I don't know what exactly 2 pages means in a digital world, but can't be too long. They really wanted to hit what they thought were the salient or the high points to help clients make an educated decision. And so it's very structured. You have language that you cannot change. So I think when you look at your Form CRS, if you don't like something in there, we'll be sure to tell you what you may not like it, but we can't change it. So there's no point in trying to wordsmith it, but they're viewed as conversation starters. They're going to put questions in there. You have to put these specific questions. You have to draw attention. They have to stand out from the other text in the document so that you're basically prompting a client or prospect to ask you questions.
And if I can just add, I think what's really interesting is that quite often when we work with our clients, the clients will say, well, really, who reads the ADV anyway? I mean, other than obviously us and you guys, but it's almost as if the SEC cherry-picked the things that they really wanted clients to read. And that's what they included in the Form CRS. So really, what does the SEC want your clients to know about? 1, fees. 2, conflicts of interest. 3, disciplinary matters. And those are some of the key things that are in it. So, the SEC is all about be careful with cherry picking, but they really did cherry pick, I think, the real hot items of what a retail client should know about you. So just kind of keep that in mind. The nice thing is, and I hope I'm not stealing your thunder, Dan, but there is nothing new fundamentally about the disclosure that you have to give. We had homework to do when this first came out. We were tasked with creating a Form CRS for a few different types of our clients. All the information was readily available to us. It was either in Part 1, Part 2A, Part 2B. So the nice thing is, it's really just a matter of taking the information from other areas and putting in a really small, concise version. The only hard part is to get it onto 2 pages. That was definitely the most difficult. Sorry, Dan.
Yeah. Oh, go ahead.
For new clients, when do you give this?
Yeah.
At the time that they sign up. So at the time when you already are giving them your Part 2A and 2B, you'd also give your Part 3 as well.
So here's the key thing to remember. What Dan was hitting on earlier about when you present your quarterly ones next year and you include it on the top, when you are meeting with a prospect and you're giving maybe your ADV, your IMA for them to sign, your Form CRS has to be on the top of that document. So if you have like a package that you give to clients, it has to be at the top. But also keep in mind, if you have an existing client, say I'm your client and I have a regular, maybe my IRA that you're managing, and then I decide I need to open up another account, you're required at that time to give them the document again. So it's any time an account opens up, not a client relationship starts. So that's going to be different. So I think the key element, in addition to just creating the document, filing it. There's the website part of it that Dan will probably talk about in a moment, but it's going to be the training of your staff to ensure that they know when to give the document, how to give the document, but the training that you're going to give to your staff on how to answer the questions that are on the document consistently across the board the same. Was there another question over there?
Is it written from the firm perspective or the advisor, like, rep perspective?
From the firm perspective.
Firm perspective, it's asked.
So it might show up at a 2B, but not on a 2A, it's not going to be in CRS.
So if there's something on the 2B, the one thing that if it is on someone's 2B, such as if you have disciplinary matters, it has to be on the Form CRS, that there is someone that has a disciplinary. Now there's ways that you can, I don't want to say wordsmith it, but present it in a way that you can point it to another document. So for instance, if you have an individual that has maybe discipline, a DRP, you can say information about our investment advisor's DRP is available here, and you can even link to the U4 filing online to the IAPD system. Yes, right after the mailing page with the address, before the letter to the clients, stick it right there. And and you may want to preface it in the letter to say, you'll notice a new disclosure document we're required to give you, just to kind of point it out, just, hey, here it is, and then it's simple enough.
Yeah, and I think that with this being such a big rule, and not just we need to add some language to a document that you may not be familiar with. This is actually requiring everyone who talks to clients to be aware that you're prompting that prospect to ask you a question. This is a fundamental change to how you prepare for meetings. This is something you have to make sure everyone's on the same page with, and that's why we really wanted to hit home with it. We did a webinar already with BAM about what this is. We talked about doing another one at the beginning, in April or May of next year, just to reiterate, this is not something that it's oh, well, now we need to check a box now, or now we need to, count our assets a different way. This is something that does affect multiple people. This isn't just whoever's in charge of compliance has to deal with this. Everyone does.
And just like your other regulatory filings, if there is ever any material changes to the document, you're required to provide it again. So if there's suddenly throughout the year a disciplinary matter comes up or you change your fee structure, you are required to provide it to your existing clients again at that point in time, which is very different than the ADV Part 2A, where if it's only a real material change, you have to provide it. So.
And as much as this changes for you, think of it this way: if you're a broker dealer, you don't have any of these documents to point to. Yeah. You can't point to your Part 1, your Part 2A, 2B. So this is really meant to help educate and bring to light some of the conflicts that they deal with, how their structure is different from yours. And so it's our hope that this helps position you all differently and helps further your offering to folks. So I mentioned Form CRS was part of that package that we want to talk about, and now Kareen's going to talk about Reg BI.
Yeah. I would love to just get by a show of hands, is anybody also a registered representative of a broker-dealer? One, okay. So just really for your purpose, but also just in general, the other aspect of the rule that was included was regulation best interest. It is specifically focused on the broker-dealer industry. If you're a registered rep only, you really won't feel too much impact by this, except for obviously now you will have your own Form CRS for the BD side of your work. But for our clients at Ascendant who are registered broker-dealers, this is going to start to impact their business to some extent. And what I mean by that is they're going to have to now develop a whole new compliance program to make sure that they're meeting the rule requirements of Reg Best Interest. So there are various different elements, and I'm not going to get so in the weeds with Reg BI because unless you own your own broker-dealer, it gets very intricate, but really the obligation now that is required on the broker-dealer industry is it includes the best interest obligation is only satisfied if there's 4 elements that they have to meet: disclosure obligation, care, the duty of care, conflicts of interest, and the compliance obligation. So they will have to then build out the compliance program around it. You will have to act at the time that you are providing advice. And the way that the SEC carved it out is not just giving advice on a security, but if you give advice on a type of account to open, so you should open up a wrap account, you should open up a non-wrap account, you should roll over your IRA or your 401k to an IRA, that is deemed advice under this rule. So we kind of wonder if the shift that we're already seeing in the industry of breakaway broker-dealers moving now to the investment advisor industry is going to continue, because this is a lot more of a burden on them. And we have seen a significant shift in people letting lapse their registered rep licenses and just moving to a true RIA only, because I think also you present yourself of, hey, we're going to be transparent, we want to act as your fiduciary, and the reality is under Reg BI, at any time that a registered rep is providing advice, it has to be in the fiduciary capacity. So it's like a tuck-in of, yes, there is the fiduciary capacity at the time. So there's a little bit of movement that's going to have to occur on the broker-dealer side, and I think compliance-wise it's going to be a burden, because there's going to be the responsibility of documenting, well, at this time I acted in the fiduciary capacity for this client, but otherwise I was not. So I just wanted to touch on that, and if there is any other questions on that BD side of it, please feel free. Afterwards we can take it offline. I don't want to spend too much time since it's not as applicable to everybody else. So I think I hit on all of that. Because we're talking about the fiduciary duty, and because of it's like the real hot topic right now, not just in DC, Washington DC, but also amongst our industry, we definitely wanted just to hit on the CFP standards. Now, keep in mind, we are experts in the Investment Advisory or Investment Advisors Act, so we did get familiar with this because there are so many of our clients that this is going to impact. The reality is the CFP board kind of felt the same way that the SEC did, which was that they felt if you are a CFP charter holder or member, they are requiring you, if you're giving financial advice, to be held to the fiduciary standard. Now again, how that will impact registered reps of broker-dealers, we'll wait and see. The rule became applicable as of October 1st of this past month. The enforcement date is next June, so they're giving people a good few months to come into compliance with the standards. One thing that you may have noticed directly yourselves, if you are a BAM Alliance, and I don't know if it was also rolled out to Loring Ward, was the investment advisory agreements were recently updated to ensure that they met the standards, because there are so many CFP members amongst the BAM community. Yeah. No, absolutely, and actually we were talking to Jake earlier about that, because we wanted to make sure that we mentioned those agreements, and we do know that there was one outstanding, which luckily enough will be forthcoming. So one other thing just to mention with the IMAs is that keep in mind that if you're using your investment management agreement to have the client attest to receipt of your ADV documents and your privacy policy, which has been standard language in the IMAs, make sure that the language is very broad to say the ADV disclosure documents, because now there's Part 2A, Part 2B, and then Form CRS. So just make sure it doesn't say you attest to receipt of the Form ADV Part 2, because now it's also Part 3. So just keep that in mind when you're looking at it. So additionally, what we provided here, this is all from the CFP website. There are some changes that you may have to make to your policies and procedures in addition to your IMA. We are presently in the process of updating for our clients that utilize us the Code of Ethics, the compliance manual as well, to address Form CRS and to address many of these things that you're seeing come rolling out, because we know that with this new rule, it's going to impact your compliance policies and procedures. So myself and Linda Noyes, who many of you know, we have been diligently working behind the scenes. We do hope to launch that in December, which actually works out well, because every December we remind you to do your annual review, and your annual review is the review of your policies and procedures. So what better time than to adopt these new policies and procedures? So we will be addressing it. But just keep in mind, if you are a CFP if you are meeting the CFP standard, reevaluate your code of ethics to just ensure that if there's anything else further that you need to include, if there's something that we missed, bring it to our attention, because like we said, we are not experts in the CFP standards, so we want to make sure that we bring your code of ethics, and I really think it's more of the code of ethics more than the compliance manual, but to meet the standards of what is now being required. So I think that kind of hits on it, but what is ironic is that many of the things that are required now under the standards, you already are held to because of the ADV, the disclosure, when to provide the disclosure. Anytime there's material changes now, it says that you have to provide all your disclosure documents again. So I think as long as you have been acting under the fiduciary duty as a registered investment advisor, these standards should not impact you too much. I think that BAM has been great with addressing the small little tweaks in the IMA to help you meet those standards additionally. Any other questions about that, just before we move on? No? Great. Well, I'm just going to kick it over to you to talk about exams.
Yeah, and just as a side note that we didn't mention, that you may be aware of, all of our presentations will be available on BAMShare with the recording as well. So I know that some of these slides have a lot on there, and it was playing tricks with my eyes earlier. So if you are having a hard time seeing that, don't worry, it will be made available on BAMShare. So,
and Jake, the past presentation we made about Form CRS a few months ago, that's available to them on BAMShare as well?
Yes, we can re-upload that, so it's
Okay.
at the top of the compliance page.
Yes. So if you weren't able to make the live presentation, it is available to you.
yeah. So one of the things that we like to cover in our annual presentation here at the conference is a topic that causes a lot of people concern, a little angst, anxiety of examinations. We're seeing an uptick across the board. And so last check, we had just over 30 clients across Ascendant that have gone through examinations thus far in 2019. And we're seeing more. They're trying to play catch up a little bit. If you remember, the government was shut down for a while. They still had goals, and so they're still trying to meet those numbers that they originally said. So a lot of times you get this letter, first you have a conversation to let you know you're getting a letter so you can have that anxiety build. But what we always say is first call should be to us, first call should be to BAM. So whether it's BAM first or us first, it doesn't matter, but we can really help walk through what these requests are. We understand that this is a very stressful time. We've been through it plenty of times, both on the consulting side, and then a lot of us have been in your shoes as well. So we are seeing an increase of examinations, and I thought one of the interesting things that we really saw was a first cyber-only exam. So yeah, I'll talk about cyber later in the presentation, but we saw the first cyber-only exam of a BAM firm. And so I think that across the BAM Alliance, there has been an approach or a thought, and rightfully so. We're on the smaller side of things. We're open-ended mutual funds, DFA. Not a lot of risk. We don't really have to worry too much. But cybersecurity is something that gets every firm in every industry, actually. And so there is no protection or goodwill earned by saying, well, we're not active, we're academically based, we don't have to worry about cyber either. And I'll talk about that a little bit later. But just because it started with cyber, they also ask for the annual review. They ask for other aspects of your compliance program. Just like in reverse, if they ask you if it's normal, it's a part of their normal examination, they'll ask you about cyber and ask you about your policies and whatnot. So what we've seen, the most common is it's about a 13 question. They call it like a light touch. They'll ask you some very basic fundamental aspects of your compliance program. Give us your policies and procedures. Show us your code of ethics. Give us a client list, and let's look at some of your holdings and whatnot. And what we found is that in those instances, when you get that examination request, or that document request, if you're able to demonstrate, I don't want to say a mastery because very few people are masters in compliance. You have other things to do other than read rules all day. But if you can show that you've got a good hold on it, yep, you want that, I'll get it to you, here you go. A lot of times if you're able to demonstrate that confidence and you can get it to them in a timely manner, you can speak on your business, how you're compensated, and you can have that conversation. A lot of times they kind of, I don't want to say go away, but they say, okay, there's nothing to see here. Where there's not smoke, they're not going to go look for fire, has been their approach, because they really want to take a risk-based approach or thinking to examinations. So it's not like you're going to get the exact same examination protocol as somebody much more complicated or different. It's tailored. So if you can give that sense of, hey, we get it. We are on top of our compliance responsibilities, they can end up being a much shorter and easier exams. And so one of the nice things is that we get the questions that are going to be on the test in advance. Through SEC examination priorities. They actually did it earlier for 2019, they did it in 2018 in December, and they said, here's all the stuff from a compliance examination that we're going to be looking at. They have a section of the SEC called OC, the Office of Compliance Inspections and Examinations, and they say, this is what we're focusing on throughout the year in our exams. This is a great thing to know what they're going to be looking at, but it also means you have to be paying attention. You can't claim you didn't know that they were going to look into it when they told you that was going to be a priority. And so as we looked at the examination priorities and we looked at the ones that are most applicable to the BAM Alliance, we looked at they give it a specific risk alert on fees and expenses. I think fees and expenses is really important to your investment philosophy anyway. Right, you're paying attention to what people are paying and whatnot. So when we look at fees and expenses, some of the things that they were focusing on was, are you using the right valuation for securities? Because you're billing on those values. I think for probably 99% of the assets, that's not an issue. Open-ended mutual funds, pricing directly from the custodians, fed into Orion. Everything works well. What you want to make sure you're paying attention to is those situations where you're using total account solutions or there's a manual entry. I know that those aren't real popular, but I think that they do still exist. BAM has done a great job of saying if there's stale pricing for even a day, you're not allowed to bill on it, which I think is a tremendous value for you all. So the way it was described to me is that even if you had for a 90-day quarter, if you had good pricing every day for 89 days, and on the 90th day, the link broke or something like that, which I know that never happens with buy all accounts. You always have good links, always have good data and login. But if it were to happen on that last day, you don't get to bill on it because you had 89 to 90. It would say, you're not allowed to do that. So really pay attention to when you look at your quarterly reports, make sure that the valuation makes sense. Make sure that what you're charging clients matches what's in the investment advisory agreement. So I think we'd all recognize, look, if the advisory agreement says one thing and we're actually charging them more, that's a huge issue, right? You definitely don't want to be doing that. You have to refund some fees. But we've even seen more issue taken lately with if you are undercharging clients. So if you are undercharging clients, we saw this in a deficiency letter where an advisor was doing this and the SEC wrote them up in their deficiency letter saying, we're not comfortable with you undercharging essentially because then we feel like it gives you the right to go back to the client and say, oh, you know how we forgot to charge you for the last 2 years? We're going to go ahead and charge all our back fees and we're going to do it all now. That would be a terrible business practice. I would not recommend that, but the SEC and the states as well, they don't work in the real world, they work in the theoretical world. And so that's another reason to say, I know when I was in-house and doing my checks, if we were charging less than we were supposed to, I'd say, you probably should change it, but we don't have to. Now I would treat that the same.
The key element of that, because I have a non-BAM client that experienced the same issue, the client came on board in 1978 with the original IMA in 1978. They decided in the 80s, 88, 89, to lower the client's fee schedule. Agreed upon, client knew about it, they did. they can't find records from that. And so the reality is what the SEC noted in the deficiency to this advisor was the fact that if you have the signed IMA, any addendums to that to lower fees or maybe even potentially to increase fees needs to be maintained, and it's part of the IMA. So regardless of a 10-year or a 5-year books and records rule, you are required to still maintain that. So it's not so much it's different from your EDV. The key element is if you've negotiated a lower fee after the original IMA was signed, you want to make sure you memorialize it and document it. Yeah, I mean, you could have them sign a whole new IMA with the lower. What we recommend at Ascendant, and you're welcome to opine in as well, but what we say is to do a 1-page addendum, note the original date of the agreement and say what has changed from the original IMA. Like you say, pursuant to the agreement, original agreement signed in 2001, we are now lowering your advisory fee or whatever the change is, and then have them sign it, just that, and keep a copy for yourself and have the client receive a copy of it as well. The emails are great, but we have seen where the SEC says, well, it's just an email, why didn't you do a change to, I mean, some way of memorializing it is the important factor. We feel that it's really best to do an addendum, and I don't know, Sal or Jake, do you feel, is that sufficient, or would you rather have a full new IMA? Yeah.
And I think you could also send that letter with the, say, hey, this is what we're doing, we just want to make sure it's in line. Just email it, confirm back and make sure that it's on you so that you could have that positive affirmation from the client. Not required, but I think that really goes a long way to say, look, everybody was well aware of it. I didn't just get the wrong email address in there, or I didn't go to an email account that they never check, but you can document there that everybody's on the same page. They also talked about elderly clients. We don't have we have a separate training on that on the ACM system. It continues to be a really big focus, and you hear that in the industry. The same applies for regulations. And so we've seen in examinations this year, actually we even saw it last year, where the SEC is asking for, show me all of your clients that are age 60 and older, show me their accounts, how much of their assets, what amount of your assets is that, what percentage overall, so they want to understand how much are you focusing on this. And so if you have the ability within a CRM system of some sort to maybe document or show, what date of birth is, to be able to highlight those elderly clients, not just because they're elderly, but technically they are more at risk for having diminished financial capacity. We're seeing that 60 is the cutoff for what they're looking at, but that means anybody could be at risk of diminished financial capacity. So they're really focusing on that as well. For our clients, we've got policies and procedures about it, we've got training, so not going to rehash that here today, but one of the things that we've seen from the SEC, and we actually just had a conference of our own a few weeks ago, I actually had to write down his title. Marshall Ganey is the Co-National Associate Director of the Investment Advisor Investment and Company Examination Program. That's a title, I tell you what. So he's kind of in charge of the compliance program at the SEC, and what he has said was, he's not trying to spring anything on anybody. Trying to be transparent. That's why we've got the examination priorities, trying to say exactly this is what you should be expecting. Wanting to say, again, he said a lot of the examinations will be light touches, and they want to see, are you trying, are you making an effort? He said that a compliance program rooted in ethical behavior, who has a line of sight into all areas of the business, is the gold star. And in his mind, he felt like compliance is a floor. He says, quote, compliance is a floor, how you keep out of trouble with a regulator. Ethics is the ceiling you should be reaching for. Behavior should be rooted in ethical conduct, not in compliant conduct. So think about that as you try to walk through whatever decision-making process you have. Is is it not just compliant, is this ethical, does this feel like the right thing to do? And if you're able to do that, you're able to demonstrate that you have a compliance program, that you care, that examinations will go a little bit easier for you, I feel like.
Yeah, I have to say that as someone at Ascendant who helps with the development of our conference agenda, we were so excited that the speaker right after Marshall Gandy was actually our 1-hour session on ethics. So we were like, wow, we timed that perfectly. So. Some of the other transparencies that the SEC has given to us, a lot goes in line with the underlining theme of protection of retail clients, which definitely seems to be Commissioner Clayton's focus, is the fact that throughout the year, over the last few years, and traditionally, OC has also offered us risk alerts. And what the risk alerts are is OC's way of saying, hey, we've done examination of X amount of advisors, and these are the deficiencies we're seeing a theme in. And what's really great about these risk alerts is it literally is saying to you, hey, if you're doing A, B, and C, and the SEC has just noted A, B, and C as an issue, I've got to clean up shop, and I've got to correct this. I mean, I have to honestly say the amount of risk alerts in the last 2 years has increased, which I think is great because it's the SEC's way of continually telling you these are the areas we're focusing on, that we're going to ask you about in exams, and we're putting you on notice that you need to make sure this stuff is right. So some of the topics over 2018 and 2019 specific to kind of this group of people that I think are really important is the advisory fee and expenses one that Dan mentioned earlier. And these are all available both on the SEC's website if you just do a search for risk alerts, or they're always addressed. They're always included in our ACM system, and anytime a risk alert comes out, we do a write-up on it, and we include it in the monthly alerts to our clients. And often, so for instance, with the advisory fee one, we try to provide a checklist that you can go through, and we'll say, these are the things that the SEC has highlighted. Are you doing this? If you are you doing that? And we try to make it in a digestible way of taking the risk alert and comparing it to your business. So those alerts and the checklists are all available to you in ACM. But specifically, some of the hot topics is best execution. How are you doing best execution? We get this often. I think literally this is something that whether it's the BAM and Loring Ward community or our clients that are hedge funds and not really private equity, but hedge funds, how do you evaluate best execution? Well, the reality is you have to be able to use qualitative and quantitative reasons as to why you've decided to use Schwab or Fidelity versus Bank of New York or any of the other competitors. BAM provides a really great comparison table. It was recently updated, and we included it in last month's alert. I'm pretty sure it was last month. And that is part of it to help you. But there are other ways that you need to memorialize this. So for instance, in this most recent best execution review that we reminded you to do, don't forget to talk about the fact that Schwab, Fidelity, TD all have gone away with the transaction fees. I mean, that's a big deal. So that's something that needs to be taken into consideration with best execution. So the key element of the alert was that the fact that the SEC felt people weren't doing a best execution review or an analysis, they weren't memorializing it, kind of that basic housekeeping things you need to make sure you're doing.
And the other thing that I commonly see is not a deficiency, but an opportunity for you all to up your best execution review is you have a duty of monitoring best execution for BAM. BAM is your fixed income sub-advisor, and BAM is actually giving you reporting on their best execution. So include that in the review along with the document that Corinne had mentioned.
Great, no, I'm glad you mentioned that. The cash solicitation rule, that if you are using, or if you have in place solicitation or referral arrangements, some of the deficiencies they noticed were the fact that advisors were not ensuring that clients were provided with the disclosure document, that they're getting a signed acknowledgement from the client, or even more importantly, that the person who is acting as a solicitor had disciplinary matters, which would prohibit them from actually receiving any cash compensation. So those are the key elements of that risk alert you need to be aware of. And remember, for firms that want to retain a solicitor to solicit clients to you, remember that there may be state licensing requirements. So that individual, depending on what state they're in, even if you're SEC registered, may be required to be an RIA, or there may be exemptions. So remember to keep that in mind, because that's something that we often get questions about, and we will need to go to the specific state to understand the state rules, because it's state by state specific. Another one is Reg SP, privacy. Privacy is a huge hot topic, which we're going to talk about in a few minutes, and some of the privacy standards that are changing. One of the things that you're going to see for our clients when you get the Red Line Code of Compliance Manual in December is the topic of supervision. So that risk alert related to if you have an advisor in your company that has had disciplinary matters, how are you supervising them? So they feel that there needs to be enhanced supervision of people that have had past historical disciplinary matters. So we are tweaking our manual a little bit to address that risk alert. So that just goes to show you how these risk alerts do filter in the manual that we get. Additionally, one other thing that I want to mention is one of the things I've seen, and I don't know if it's me, but I have a lot of clients going through SEC exams right now. Like, I swear, it's not me, but is the topic of share class, mutual fund share class. The SEC is all over it. For you guys, and I went through an exam with the BAM firm that said, we use DFA funds. But believe it or not, the examiner found 3 funds that were invested in that were not the cheapest share class. They were on 401k platforms where the advisor didn't have a choice of what funds that were available. So another thing that we are recommending firms do is adopt a mutual fund share class policy on how you're looking at share classes, because the share class initiative was a huge thing. I mean, just only within 2 weeks ago, there were another 16 advisory firms that were sanctioned by the SEC because of share class consideration. So hot topic, we're gonna address it in your policies and procedures. Yep. Yeah, no, absolutely, they are so focused on it. I don't know how many times, and I actually physically was on site with this particular client to help with their exam, and we were like, there's no 12B1 fees, there's nothing, there's no other compensation, because that's really what they're looking for. But more importantly, what we had to do is we said to the examiner, we are in the process of adopting policies and procedures, and with respect to assets that transfer in, policy that also addresses how you're going to look at those. And is there tax considerations to keep those versus moving the client to a different share class? So the important thing for the SEC, I think, especially with exams, is the policies that you have and that you're following. And the reality is, especially for BAM firms, we never really thought of this was important to have a policy on, but now we're seeing the importance of it and we are rolling that out.
But I think that them uncovering that issue just for a couple days is not to scare you, but the SEC has tremendous technology capabilities. I think Larry's got a famous saying, torture the data until it confesses. If there's something that is off, there's a good chance they find it. So I don't want to say that to scare you, but if you do find something that is off, even if it's something minor, talk to BAM, figure out how to get it right in Orion. Do we need to rerun reports? Is there anything that needs to be redone from a billing perspective? Because don't take the perspective, oh, that's 0.1% of the client's assets. They'll focus on that 0.1. They don't care, you don't get credit for the 99.9.
No, in this case it wasn't. It was another administrator, and luckily enough, after we explained the fact that they're limited in what selections they can make because it's limited to what funds are on the platform, they actually were comfortable with that explanation. They were more so of, well, you say that you always go for the lowest class, but then why do you have these? And it was just explaining that. I think I can talk to Kristen. I can talk to Kristen about that to see if there's anything that would be concerning and bring this to her attention, because I know this happened just recently and I haven't had a chance to talk to her about it, but that is a great question. So if it's okay, if we can follow up with you on that, that would be great. One other thing, and I know we're getting kind of close to the time, so if you use cloud storage, that one of the risk alerts discuss the use of cloud storage and some of the controls that you should have in place on those cloud storages. So if you back up to a cloud, take a look at that, which I think leads us into our next topic of why they're so focused on cybersecurity.
Yeah, cybersecurity, as I mentioned earlier, affects every business in every industry. And this was recognized by the SEC back in 2014, saying, hey, Home Depot is getting hacked, Apple's hacked, Target is hacked. What about advisors? What are you all doing? So they started an initiative in 2014 as more exploratory, saying, hey, we never told you what you have to do. So what do you do? And they were just kind of just finding things out. Then back in 2017, they went back to those firms and said, okay, well, we talked to you before. What are you doing now? Have you changed anything? We actually saw some deficiencies come out of that. And then this was mentioned in the exam priorities for 2019. And so, again, they're not too prescriptive in what you need. This is what they say you should have. It's at a high level, talking about basically, I won't go through every one of these things, but what information do you have? Where is that information? Who has access to that information? How do people get access to that information? How is access taken away? And so I mentioned that cyber exam of a BAM firm earlier. They said, okay, do you have an onboarding checklist? Okay, yeah, we do. So when someone gets hired on, we reach out to BAM and we get a login to BAM, and talk to Ascendant and we get a login to Ascendant, and we talk to the custodians and whatnot. They said, okay, great. Do you have a checklist also for when they leave? And they said, oh yeah, we remove access. We send this email and said, okay, great. For the last 5 people who started and the last 5 people who left, show us documentation that how they were granted access and when it was taken away. And I think that's where they fell down and said, well, this is a pretty easy process. I just email BAM and say, this so-and-so doesn't work here anymore. Okay, well, is that documented? Did you get something back? And so really for them, it was really a documentation issue. So they talk about, again, some other things at a high level. And if we look on the next slide, we've got some resources here that you can use that were published by, FINRA has a cybersecurity checklist, NASA, which is all the state advisors kind of look towards NASA for model policies and procedures. They're good resources. They're good checklists for you to consider things. Now, we're not cybersecurity experts. I understand in the industry, you didn't go to school for this stuff, and so you typically outsource it. So, number one, you should use it just to educate yourself a little bit as to what the expectations are, because you'll have to answer these types of questions. And then number two, if you are outsourcing this to a third party, run it by them. Say, hey, I've got to be held to these standards. What are we doing with this? Because they're telling us, again, they're giving us the questions to the test in advance. How are we doing these kinds of things? And so some states have adopted the model package. And we talk about that a little bit more on the next slide. And if you read this, again, it's not very tangible. It's a lot like the compliance program rule. The compliance program rule says you have to have policies and procedures that are reasonably designed to prevent violations. You should be able to prevent, detect, and correct violations of securities law. You say, okay, well, that's great, so what do I do, right? They tell you what the goal is. And so, some states have adopted this, and so you really need to make sure if you're state registered to check through it. Again, if you're SEC registered, it's good information to consider. But so practically, what can you do? And this is, on the next slide, we talk about a white paper that we have in the back that was written by one of our colleagues that helps think, what can you do tangibly? There's no one size fits all. We can't tell you exactly, make sure your encryption level is up to this level or things of that nature. But think about this, just kind of do it a little bit practical if you're not doing anything to start out. Make sure that you are installing updates when they're available. Make sure that you have strong passwords. Consider dual authentication. I even have dual authentication in my personal email. And so think about the information you have. If you can turn on that where it pings your phone. Don't use the same password. Don't do that personally and also professionally. Know where you're going when you click on a link. You can put your mouse over it, it'll pop up where you go. if it's possible, segregate access. I know a lot of BAM firms, everybody has access to everything, and that's just how you work. But if you don't have to have it, limit the potential ins, because the number one the number one weakness in your cybersecurity program is your people. So if you can limit who has access to what, then I think that'll be great. And then monitoring the access of failed attempts. And what we really talk about here is if you have a third party that is providing some services to you, what kind of reporting do you get from that third party? You're paying them every month. You should probably get something back from them to say, oh yeah, we have been doing this, we had X number of attempts, we're monitoring your firewall. Get something so you can have some sort of basis to say, I'm not an expert, I've hired an expert, and here is the results of what they do for us. And before I turn it over to Karine, the last thing on cybersecurity is, if you have any concerns about cybersecurity, or if you just want to have some peace of mind, we do have services at Ascendant where we can do some vulnerability testing for you, penetration testing, and really kind of give you a checkup, and we can have those conversations to help give you a little. When I talk to advisors, they say that cybersecurity is the one thing that keeps them up at night, because I'm not an IT person, I'm a numbers person, so I really hope we didn't get hacked last night, and I'll find out when I go in the morning. So.
Yeah, absolutely. And for firms that are state registered, and if your state has adopted the NASA model rule, you can sleep at night knowing that the incident management and response, the oversight of third-party vendors, and the cybersecurity policies that Ascendant rolled out a few years ago would satisfy that element. So that's kind of a good thing. We did evaluate the model rules, and we made sure that our policies and procedures that we rolled out probably about 3 or 4 years ago now would satisfy the regulators' requests. So I just wanted to kind of talk about for a few minutes, and I know we're probably running out of time because Dan just doesn't shut up. No. But privacy rules, so about a year or two ago, the big privacy rules that really didn't impact the BAM community was GDPR in the European Union. It really rolled out some very strict standards for privacy when you maintain client information, consumer information. California has already adopted, and it is going into effect next year, their own privacy standards. So if you have clients in the state of California, you should become familiar with it. Or if you're located in the state of California, you should become familiar with it. The key parts of the rule that I just want to highlight, and one of the parts of the rule is that whether or not you earn more than $25 million in revenue, or if you have, I think it's 7,000 clients in the state. But the reality is, regardless of if you meet those standards, you need to be aware of this, because California is not the only state that are rolling out these privacy standards. As of about 2 weeks ago or a week ago, when Dan and I finalized these slides, there were over 100 rules in legislation across the United States and in various different municipalities. So for instance, I'm located in New York. New York passed 2 such bills, or the SHIELD Act and then the DFS rule. So that's impacting advisors that are located in the state of New York. So remember, you may be in one state, but there may be a privacy rule in another state, and if your client is located in that state, it could impact you. So how is this impacting you? One of the things we saw when GDPR came about was the fact that we had to see privacy policies change. We are actually actively looking at the privacy policy that we have a template for to determine if it's meeting the standards of some of these new regulations. And so if you're a client of Ascendant, you may see in the next coming, I'm not going to say weeks, but probably maybe in the first quarter of next year, we may be enhancing the privacy policy that we've traditionally given to you. Because there's things such as opting out of sharing of information that needs to be addressed. There's also the importance of due diligence, of knowing which vendors have your client's information. So for instance, if you're an advisor using BAM, BAM is now a vendor that maintains your client information. These are some of the things that they want to see that you inventory. One aspect that we've gotten some questions on, because, and this slide, and I don't know if it's very legible, PricewaterhouseCoopers did a comparison when California passed this legislation of the CCPA versus GDPR and comparing similarities. One question we got was, well, there is a part of the rule that says that if a client calls me and says they want me to delete their information, what do I do? Well, remember, if you are obligated under books and records rule, under SEC rule or state rules to maintain that information, then you cannot delete it. And that needs to be communicated to the client. So that's one part of it. So really, we just wanted to hit on this because in the next 6 months, we think we're going to see other states. Nevada's already passed a state. Massachusetts has had very strict. So for instance, if you have clients in Massachusetts and you're ever sending an email to them that has client non-public information, it needs to be encrypted. For anybody that doesn't know that, that's been in effect for years. But this is now kind of going beyond just the cybersecurity concern, but the whole privacy concern. And we're going to see more and more of that probably in the coming few years. So we just wanted to just touch on that briefly as well. I think we're out of time. Dan, myself, Keith, and Vicki, we are here. We're out at the booth. Please come by, take a water bottle, a notebook. I just want to say thank you. I know there were probably 5 sessions at the same time, so the fact that you have carved out time to make compliance a priority really means a lot to us. So
Give
thank
yourself
you.
credit in your files.
Yes,
for
yes.
coming
That
here. This
you
does
get
count
this
as
is
compliance training.
it counts as compliance
100%.
training. So
Yeah. Thank you.
thank you guys.